Hello and welcome to this modern criminal law review event entitled From Treason to Trump, Felonies, Medieval Origins, and Modern Resilience, a book forum. My name is Elizabeth Kamali, and I teach criminal law and legal history at Harvard Law School. I'm pleased to serve as the moderator of today's book forum, which will involve a discussion of a new book from Oxford University Press, The Making of Felony Procedure in Middle English Literature, by Professor Elise Wang from Cal State Fullerton. In the book, Professor Wang explores the medieval origins and modern resilience of the concept of felony in contemporary criminal law. Commentators, historians, and judges have long spoken about the evil characteristic of those defined as felons. To take an example, from Pollock and Maitland's late 19th century history of English law, quote, "When the adjective felon first appears, it seems to mean cruel, fierce, wicked, base. Occasionally, we may hear in it a note of admiration, for fierceness may shade off into laudable courage." Think Robin Hood. That's not from Pollock and Maitland, but from Kamali. But in general, it is as bad a word as you can give to man or thing, and it will stand equally well for many kinds of badness, for ferocity, cowardice, craft, end quote. Now, more startling than Pollock and Maitland's sharp definition of felon is the survival of the terminology of felony and felon in modern criminal law discourse. In public conversation today, the branding of a criminal defendant as a felon still seems to point to their exclusion from the political community, something in the nature of civil death or outlawry, but in the form of modern collateral consequences, whether disenfranchisement, deportation, or ineligibility for certain job benefits or jobs in the first place. So how can this be? In our book forum today, we will address questions like, what did felony mean in medieval law and literature? What does and what should it mean today? Does felony have a place in modern criminal law discourse and practice? In today's event, an interdisciplinary group of scholars from law, literature, and history will reflect on Professor Wang's book with the broader aim of exploring the making and contemporary significance or resonance of historical concepts such as felony and their possible analogs in other legal systems. To start things off, Professor Wang will briefly introduce the core idea of the book, and after that, our distinguished commentators will each speak for about 10 minutes to share their comments, questions, and critiques. I will introduce them later, but briefly, they are Sarah Butler, Jennifer Johnner, Alice Ristroff, and Jamie Taylor. After the author's response to the comments, we will then open a discussion among the group, and there will be an opportunity at that point for the audience to pose questions through the YouTube chat. The proceedings of this event will be available later in an MCLR Plus online book forum. All right, without any further ado, it's time for Professor Elise Wang to provide us an introduction of her book. Professor Wang.
Thank you so much. I thank you all for being here, to Marcus for putting this together, and then to Liz for moderating, but also for being such an inspiration and kind supporter of this book. And then to all of you, Jen, Alice, Sarah, Jamie, I hope now, having read the book, you can see just how much of it is indebted to all of you, really a sort of excessive amount. And therefore, what an honor it is to have you all here to talk about it. So to introduce the book, I thought I'd talk a little bit about its conceptual evolution, because I don't think that's clear in the book itself. So when I'm helping my students learn to start a longer research project, I recommend they start, with a small observation, some small peculiarities that causes friction in their brains, something that's hard to let go. And the small peculiarity for me with this book was actually something that someone else couldn't let go. So William Langland wrote Piers Plowman at the end of the 14th century. And if you've not had the pleasure, he was many things, but he was definitely the crankiest writer of the 14th century. So the poem goes about snarling about a lot of things, but a story that Langland really seems to worry over, it's a different kind of affect, is the story of the good thief. So he comes back to it 3, maybe 4 separate times in different sections by 3 different characters. This is a thing that keeps coming back for him. The good thief was crucified next to Christ after a life of felony, as the poem puts it, but is the first to be saved. So as far as most medieval commentaries are concerned, this is a totally solved problem. The contrast is the point. It shows the power and mercy of God that a base thief can be the first to heaven. But Langland's not satisfied. He knows this history. He quotes it. He's not satisfied with it. And you can watch him attempt to wrench justice into what he clearly feels is a structurally unjust story. A felon is saved before John the Baptist, he says, and he keeps on repeating felon. And this isn't the word that scripture uses. This is the word that Langland provides. And what he ends on is untenable, theologically speaking. He proposes that, sure, okay, whatever, he can be saved first, but that doesn't mean anything. Also, the saints will sit at the table of heaven, but the felons have to sit on the floor and eat their scraps. So he invents these levels of heaven. He seems aware that he can't actually damn a man that Christ has already saved, but he's doing his level best. So this is strange because he's cranky, but he's not a Pelagian. He doesn't actually believe that salvation is earned. And he's known for dealing with theological questions with some subtlety. So my small peculiarity, the friction, was why is this the story that pushes him into this heretical thinking? And so I looked around at other uses of felon in literature, and as Liz was just saying, it seems to be a synonym for cruelty, but specifically it seems to be a word for the villains of the story. So Ganelon in Chanson de Roland, it's Judas in Handling Sin, it's Mordred in Norman Arthurian literature, it's the arch villain. Okay, so then I had to know, what is a felon? So felony started as treasonous insubordination, but by the late Middle Ages, felony is a category of crime for which the punishment is death and forfeiture of property. So there are other options too, like abjuration, but the idea was that you lost your property, you lost your foothold in the community, because felony is the thing you don't come back from. And this, as Liz was saying, is still true today. Even if you serve your time, felony usually has a wide array of permanent collateral consequences, most famously disenfranchisement, but also you can be barred from licensing for certain professions. There can be a loss of social services. It can be grounds for divorce and termination of parental rights in some cases. So actually, as a legal term, it's been very conceptually stable over its 700-year history. But you might notice what I noticed, which is this is an answer to what do we do to felons, not what felony is. Okay, so what makes an act a felony? And this is where it gets more confusing. Now, I'll preface this by saying medieval lawmen love the weeds. If you want to know what they think about leases in a leap year, boy, do they have thoughts. So which is what makes it surprising that there are very few weeds here. They don't get into the technicalities of what felony is. Part of this is just that medieval lawmen like to think about property, not about crime. But so it ends up that there's no positive definition of felony in the period. As Maitland noted, quote, "It can only be known by its legal effects, that is, by how we punish it. Any definition that would turn on the quality of the crime is unattainable." And this too is true today. We define felony as any offense punishable by more than a year in prison. So in other words, we can't say what felony is, but we will know it when we have punished it. So felony is its prosecution. As a conceptual problem, I dig into this throughout the book, but especially in the epilogue. But then as a practical problem, that means we have to look for the concepts if we want to know what felony is. We have to look for the concepts it builds through its prosecution. In this case, specifically in the work of local communities that were left to shape this process by these disinterested lawmen. And tasked with a weighty responsibility, they turned for guidance to previous cases if they knew them, but they also turned to plays they had seen, poetry they knew, sermons they had heard, this sort of cultural landscape. And that project is what this book is about. I argue that felony and its procedure were an anchor for this shared conversation in law, in literature, in religious writings about what truly earns exclusion from society, because felony is what you don't come back from. This conversation included the people who built the procedure and made the documents of felony procedure, but also the poets who wrote in order to imagine a more just disposition for their world, because who we exclude tells us who we are. So that's the subject. And I'll just say one more thing. In the shaping of the book, a big part of my heart lay in the methodology that emerged from this, from investigating this question. I think the concept of felony is an example where the quest for answers to conceptual questions, especially in the Middle Ages, is hampered by disciplinary boundaries. So I wanted to give an example of what it might look like, imperfect as it is, if we let ourselves think across those conversations. And then also within this advocacy for interdisciplinarity, I admit to wanting to swing the balance just a bit towards literature, just like a little bit towards literature. Because in any field that combines literature with another discipline, so law and literature, literature and economics, a kind of shared custody agreement develops, and it tends not to be in literature's favor, in my opinion. In law and literature, for example, literature ends up having kind of the cultural context, the flavor, but legal history has the stakes. And so that means we ask legal historical questions. They both have the sources, but again, if legal history has the stakes, then they also have the methodology, which means that literary sources will do their work less well. And I think felony procedure is one area. I think there are a great deal more where we can productively mix and match. So there are historical questions I ask here, like if people are worried about the corruption of oath-worthy men in a testimonial system, that I answer with literary sources, like a reading of the Epistle of Sweet Susan. But there are also literary questions I ask, like what is going on with the confusing temporality of St. Erkenwald, that I answer with historical sources and methodology. So each chapter is an attempt to find a different kind of conclusion that we can draw from mixing these questions and sources and methods. So I think this did end up with an intentional sacrifice that I made, which is, I think, a legitimate weakness of the book as a monograph in medieval studies, to sacrifice a larger through line for an exploration of this methodology. So I don't regret it, but I do think there are some jarring moments going from chapter to chapter, because each one is an attempt to sort of figure out a different mix and what comes out of that methodologically. So each chapter matches a literary text or two with a few felony cases. And the order of the chapters roughly follows the steps of a felony investigation, or at least the parts. The first one is on the death investigation and St. Erkenwald. The second is on the plea with some Chaucer and Gower. The third is on testimony and the Epistle of Sweet Susan. The fourth is on the documents and Piers Plowman, and then Standing Mute and the mystery plays and the Mum and the Sausager is how I end it. So I'll just end it there, and I really am looking forward to hearing your thoughts.
Wonderful. Thank you so much, Professor Wang, for that wonderful introduction to your book. And I suspect I will never think of Langland as anything but cranky Langland going forward. And also, thank you for helping us think creatively about how to deal with disciplinary boundaries, which I think is really, what I see as one of the key contributions of your book and its very creative methodology. We're going to turn to our commentators now. Our first commentator is Sarah Butler, professor and King George III Chair in British History at Ohio State University. Professor Butler is the author of many, many things, but in each case, I'll just name one written work. In this case, I'll mention her book, Pain, Penance, and Protest, Pain, Fort et Dure in Medieval England. Professor Butler.
For those in the audience who have not yet read the book, let me assure you that it is not the slightest bit jarring moving from chapter to chapter. It moves smoothly and beautifully. And I'm absolutely delighted to be able to participate in this forum today on such a wonderful book. Elise Wang's The Making of Felony Procedure makes the definitive argument for why legal historians cannot afford to ignore literature. Literary scholars have acknowledged repeatedly that medieval writers were not bound by the conventions of genre. They didn't recognize that different rules should apply to different modes of writing. And because of that, we often see unexpected borrowings. For example, a medieval chronicler might shape an historical account following the narrative structure of a favorite romance, even though that meant departing from the truth as to what actually happened. It's about effective writing, not sticking to the facts. Indeed, that 14th century poets often held jobs as bureaucrats is probably the best reminder that we can come up with that a text is a text is a text. We shouldn't get our knickers in a twist about genre. In this environment, there was no way for law to exist as an unpolluted genre. Poetry and law not only coexisted, they interacted. Arvin Thomas has made this argument in his recent book, Piers Plowman and the Reinvention of Church Law in the Late Middle Ages. He has argued convincingly that our cranky poet Langland, in his Piers Plowman, was not just touching on subjects of interest to canon lawyers. Through the text, Langland was participating in some of canon law's most interesting debates on penance and pastoral care. He used Piers Plowman as a means to sway opinion and forge new law. But in looking at just one text, it might appear that Langland was doing something exceptional. Elise Wang's The Making of Felony Procedure takes up this banner by examining a multiplicity of texts, and in doing so, she makes it clear that Langland was doing what everyone else was doing. Her book shines a light on the various ways that medieval writers used literature to flesh out the law and participated in defining its procedures. Medieval English common law is frustrating. I think we all need to admit that. It is frustrating, but mostly it's frustrating because it's a body of unwritten law, which means we don't know precisely what it included. Now, thankfully for us, some 12th and 13th century jurists realized how problematic it was to try cases based on unwritten law and tried to start some systematization by writing legal treatises. These are the names you've all heard at various points: Glanville, Bracton, Britton, Fleda, the Mirror of Justices. Granted, at times, these treatises create even more problems for the historian, and I'm sure also for their peers, because in trying to be comprehensive, their authors drew on Roman law to fill in the gaps in their knowledge. As a result, the treatises are sometimes about actual practice, but not always, and it's up to the scholar to try to figure out which is which. We also, of course, have statute law, which came into being essentially with Magna Carta and which acts as a corrective to common law when people felt the law needed to be refined or clarified, or as a means of adding to the law for new situations not covered by old law. Statutes frequently refer to existing law, thus opening a window for historians into the secrets of the common law. And finally, we have the records themselves, where justices presided over cases in which the law was implemented, probably our best guide to understanding common law. But none of these guides start from scratch. They all assume a basic knowledge of common law, and so definitions for what may seem like essential terms are just not there. I've always thought that reading medieval statute law in particular is sort of like starting a book series on volume 3. You're always trying to figure out what the heck you missed, and none of the basics are explained. Now, Wang begins her book with a sense of exasperation because medieval law included no definition of felony. Well, believe you me, there are many other terms I sure wish someone back then had bothered to define. Raptus, anyone? Anyone? But yes, felony is nowhere defined. And I might also point out, crime is a term that was never defined. And for all those of us who sit back and say, oh, felony is just a serious crime, that's a hard definition to maintain when we don't have definitions for crime either. So how could they not have defined these things that seem so basic to the running of the law? Of course, I think in many respects, we are the problem here. We come from a system where we see a clear division between criminal and civil jurisdictions, which makes it integral to define what we mean by criminal, what we mean by felony. But the medieval world did not. The English crown instead divided things into civil pleas and pleas of the crown. But pleas of the crown involved a whole heck of a lot more than just felonies. Crown pleas for anything touching the king's peace. And since felony was a breach of the king's peace, of course it was included. But so too was treasure trove, shipwreck, beached whales. Civil pleas also included a lot of what we today would call criminal misdemeanors, assault, petty theft. So our division between civil and criminal, no matter how much we might want to map it onto the Middle Ages, just doesn't work. And my point here, medieval law didn't define felony because lawmakers did not see felony as the key term. I think defining it would have made no difference to them. They knew which offenses were included in the pleas of the crown, so they knew what to try, and that's what really mattered to them. Why define it if you don't have to? But that, of course, still leaves us scratching our heads. How did medieval people know what the term felony meant? Well, for this, Wang points out we need to look to the practice of the law, which was not in the hands of lawmakers or even royal justices. For that matter, the accusation investigation processes were left up to the people. She makes this argument in chapter 1, and I'm going to say chapter 1 is absolutely my favorite chapter. I adored every minute of it, so I'm going to spend a little bit of time here dwelling on that. But I loved it chiefly because of the intense focus on the community and its role in the investigative process. A lot of hullabaloo has been made of the fact that pre-modern England had no rules of evidence. And because trials were so short, roughly 15 minutes, and clearly did not include the presentation of evidence, some scholars have assumed that there was no evidentiary bar whatsoever. And clearly that's problematic. Wang shows just how wrong that belief is by turning to the 14th century story of St. Erkenwald, in which the townspeople of London from a much earlier time discover a tomb that no one knows anything about. They don't know who the person was or how he died. So they call Bishop Erkenwald to come intervene and act as the coroner in an inquest into the death. The story includes a very full description of the investigative process, something I sure wish I had known when I was writing a book about the coroner's inquest. Wang likens this to crowdsourcing, which I still think is one of the most useful analogies. Wang demonstrates that evidence did matter. Indeed, there was even a hierarchy of evidence. The body and what it can tell us mattered most. But jurors examined also witness depositions, taking into account the credibility of individual witnesses and making an effort to verify the information they put forward. Jurors looked at written documentation when it was thought that there might be something relevant. In this case, they went looking at old inquest records, hoping to find something about the newly discovered corpse. And above all, jurors sought the truth of what happened. Now, there are a few key points that Wang makes in this chapter that I really want to highlight. First, the community did not wait until the coroners showed up to get working. The investigation was a community-led initiative that began the moment they found the body. So what can we learn from that? What we learn is that the focus has got to be on the community. They did the investigation. They sorted through the evidence. They decided who to accuse. Medieval law was people-centered law. It really wasn't about lawyers or judges, or at the very least, this is true when we're talking about criminal law enforcement in this period. Really, it's not about lawyers and judges because we don't have lawyers involved in prosecution or defense in the same way. And judges never had an opportunity to hear all the evidence. So they probably had no clue whether the people standing in front of them were guilty or innocent. I'm going to hazard a guess that honestly, they didn't really care. It was about getting the job done and keeping things organized. I also suspect that is why most legal historians today aren't particularly interested in the history of criminal law, because the real stars are the anonymous nobodies. Sorry, but most legal historians are lawyers, and this isn't about them. But Elise Wang does an excellent job of showing that these anonymous nobodies have lasting influence on the law, and their actions and decisions are worthy of our attention. Second, Elise Wang also shows us that jurors actually wanted to know what happened. Richard First Green's book, A Crisis of Truth, as wonderful and as helpful as it is for understanding perceptions of law in the era, has led some scholars to dismiss the validity of fact-finding in the era. Green argues that jurors weren't necessarily judging the truth of the facts, but the truth of the defendant, i.e. his or her reputation. While that aspect certainly played a role in the law, it seems clear that coroner's inquest juries were keen also to find out what happened. They were intent also in looking for the truth as we know it. And I think that's an important intervention to be making in the scholarly literature. Wang argues that the author of St. Erkenwald sought to set standards for the use of witnesses and evidence in the pursuit of justice. I'm going to admit, without more evidence about practice at the time, I'm not sure if we can tell whether the author was setting a bar, trying to maintain a bar, or simply reflecting current practice. Nevertheless, Wang goes a long way towards redeeming the medieval coroner's inquest in the medieval criminal justice process, but especially refocusing our lens on who really matters, the community and its role in the investigation. Now, one point I would like to make is that we need to be careful about judging medieval law from medieval standards, particularly. And I think I've hinted that a bit with my suggestion that I'm not sure that medieval lawmakers really cared about what felony meant, although I do agree that regular people did. In the same vein, I see a touch of anachronism in Chapter 4, which is built on the premise that English criminal justice was a failed system, because most criminals were never convicted for their crimes. They weren't even just not convicted. Most of them were never tried. Flight rates were something like 70%. But to call this a failure, I think, is too modern an assessment. Conviction rates are a modern marker of success, but they weren't a marker for the Middle Ages. Medieval lawmakers cared about the restoration of the king's peace, which could be accomplished easily without conviction. And conviction was not the only means available to punish a criminal. Medieval communities saw indictment as a form of punishment. After a couple of years in prison awaiting trial, the perpetrator had learned his or her lesson. Conviction wasn't necessary, and probably not even desirable, given the fact that conviction of felony always meant execution. And even for those who fled, from a medieval perspective, a formal accusation in absentia punished the perpetrator. He or she could not easily return, and so they were isolated from family, friends, and any decent means of financial support. And with the criminal expelled from the community, everyone else could set to work restoring the king's peace. Everyone wins. Execution should not be our measure of whether the medieval criminal justice system was a success, but it doesn't seem like it was their measure. And I think this is true even if we are looking at things from the perspective of the king. With the number of pardons that the king gave out, it seems pretty clear that kings in general did not see that putting people to death was the goal. Now, to wind things up, Elise Wang's book makes us think more deeply about the relationship between law and literature. She makes it clear that this was not a one-way relationship. Literature did not just reflect law. It participated in the refining of law and the creation of a jurisprudence. Ignoring the literature and all the useful tools that literary scholars have to help us understand the law means that legal historians are going to miss out on a fuller understanding of medieval law and its procedures. Thank you.
Thank you, Professor Butler, for those wonderful comments and for reminding us that law is not an unpolluted genre, and that, in fact, we'll be disappointed if we're seeking an unpolluted genre in our medieval English source texts. Also for the, articulating the idea that the medieval English common law is frustrating. I think we could start a support group from the base we have here on this Zoom call. And I incidentally would also join the fan group for Chapter 1, which I hope we can discuss further in the Q&A portion of today's event. But first, let's turn to our second commentator, Jennifer Johnner, Professor of English and Dean of Undergraduate Students at Caltech. Dean Johnner is the author of Literature and Law in the Era of Magna Carta, among many, many other things. And I now turn over the floor to her.
Well, I'll join Sarah, Liz, and everyone else in congratulating Elise on just a fantastic book. I've had the pleasure of watching this project develop over years. And to be able to read the final product is just such a testament to your supple and ambitious way of thinking. So I really appreciate it, and thank you. By way of warning, it's been a very difficult week or two for Caltech, and the time that I had allotted to write my comments was taken up last week by a literal firestorm. So I haven't had a chance to really digest for myself what I'm saying, and I look forward to other people telling me what I'm trying to get at with my own comments. So without further ado, so again, I'll just start by reiterating some points that Sarah has already made about what I see as some of Elise's key interventions for those of us who work in law and literature. And I count myself among the law and literature group, trying to move across those domains and understand how they speak to each other. I think, Elise's book is so accomplished and so provocative. And I think for me, it's prompting us to think deeply about what I think of as the law's rhetoricity, so its dependence on language to persuade, as well as its logicality. So that would be its self-appointed capacity to demarcate or to seem to demarcate categories of persons, actions, and things. Felony, Elise aptly argues, emerges at precisely this juncture between persuasion and categorization, between law as an argument, something that's trying to persuade us of something, and law as a description, something that's telling us what happened, what is. And I think the brilliant intervention of her book lies in her tracing of the fundamental interdependence of persuasion and categorization in the, quote, Making of Felony Procedure. As she explains in her introduction, and as Sarah has also discussed, felony in its medieval origins is less an act than an effect. It came into existence to measure degrees of wrongdoing and proved a lasting and capacious concept to our own present day by never having to supply a definition of the wrongful act per se. The act of felony, she writes, cannot be known before the law has treated it as a felony. But in order to treat it as a felony, the law must pretend that it recognizes its object. So one way of describing the arc of Elise's book is as a study in how law and literature create and recognize their objects. That is, how they amass the circumstantial details that appeal to audiences as persuasive, verisimilar, and credible. In law, we tend to treat these details as evidence, admitting or excluding them from consideration based on our chosen standard. In literature, these details become the very stuff of narrative. Each new piece of evidential detail helps build character, setting, tension, and resolution. And the field of medieval law and literature has long recognized the uneasy proximity between these two modes. As Elise notes, the language of the early common law is suffused with terms that recognized law as a form of storytelling and storytelling as potentially legally probative. The Anglo-French verb conter, for example, meant both to recount a narrative and to enter a plea in a legal case. And they both share a common root in the Latin verb computare, to reckon, account for, tabulate, compute. So if I could take away just one insight from Elise's book, and fortunately, I don't have to take away just one, but many, it would be that felony lies at the heart of law's accounting, its capacities to determine fact, measure harm, and apply remedy. Felony in this way is what we might call a rhetorically copious legal category. It requires a large tally of wrongdoing, corroborated by a high degree of credible evidence to come into effect. As Elise shows across her chapters, this makes felony a useful lens for analyzing techniques of literary accounting too, as the same details that serve to corroborate a crime also build narrative richness and realism. And here we come again to that tricky entanglement of fact and argument and evidence and persuasion that have bound law and literature together since the classical era. So as we've heard, each chapter of Elise's book trains our attention on a different genre of medieval literary storytelling, and with it, a different set of evidential procedural questions. I'd like to focus my comments today, this works out very nicely actually with what Sarah started with, on her second chapter, which treats a text that I'm also fascinated by, known as the Placida Coronae, or the Pleas of the Crown. This is another one of those weird medieval treatises. It's written in French in the second half of the 13th century, And it provides insight. It's not totally clear insight into what. So part of what I'm trying to do is, with Elise, work through what this text is trying to give us access to. It would seem to be insight into criminal pleading procedures in medieval courts, but it's not a legal summa. It's drawing from a text like Bracton, but it's not like Bracton. It's not didactic in any kind of explicit way. The best way I could describe it is kind of like a loose compendium of medieval mock trial transcripts. So scenarios that approximate actual legal cases while being unusual enough to solidify key principles of pleading. So take, for instance, the woman's appeal for the killing of her husband in her arms. In this case, we are first presented with the voice of what we can assume is the kind of appellant's attorney, who's going to set out for our woman the terms of her appeal. So you have to imagine this in the voice of whoever is our reader. Agnes de N, who is here, appeals Robert de C, who is there, that whereas John, her husband, and herself were in the peace of God and in the peace of our Lord the King on such a day, at such an hour, in such a year, in such a township, namely in the middle of the township, in a certain place called N, lying towards the east, there came this same Robert, who is there, feloniously as a felon, and in premeditated attack, and called them vile names, inasmuch as he called them thieves and faithless ones. And then he drew a newly sharpened cologne sword and ran towards John, her husband, feloniously as a felon, and intending to kill him. And whereas she held John, her husband, in her arms to shield him from the felony, Robert came feloniously as a felon and wounded him with the point of his same cologne sword, which was so sharp that it inflicted a wound in the middle of the top of his head, causing blood to be shed, and shed his brains, so that he died soon afterwards in her arms. And when Robert realized that he had committed this felony, he at once ran away. Okay, this is a really strange rhetorical text. And scholars have never been under the impression that the Placet Coronae was meant to serve as a reflection of actual practice. But we can't also say that it was particularly obscure. It survives, as Elise notes, in a number of manuscripts. It clearly was serving a purpose. So what might we understand that to be? In her chapter, Elise argues that one purpose of Placet Coronae cases, such as the one I've given you, was to supply what she calls narrative satisfaction for judge, jury, and audience, including readers and users of the manual. Narrative, she suggests, serves as the book's central area of concern. Recognizing that fact, in Elise's words, allows us to, quote, see that the legal manual considers learning to satisfy narrative expectations as an area of study in itself, and that it draws deftly upon the literary training of the medieval reader to further this education. In other words, and I'm still quoting Elise here, I believe this instructional text demonstrates that not only did pleaders recognize that they were telling stories, they were also invested in honing that craft. So in the bit of time I have left, I'd like to follow Elise's invitation to take narrative construction seriously as a primary aim of the Placet Coronae and of felony pleading procedure generally. Elise rightly argues, I think, that, quote, narrative satisfaction is where law and literature intersect most powerfully and often troublingly in her corpus. Satisfaction, satisfaction, often served as a synonym for compensatory justice in Middle English. But, as Elise discusses, satisfaction also serves to close a narrative in ways that may or may not serve the truth. Felony procedure, from inquest to pleading to prosecution, defense, turned on the ability to marshal not just the bare events of a case, but the qualifying circumstances that elevated that case to a felony offense. And I'd like to spend a little more time digging into this important insight from the vantage of medieval rhetoric, in part to appreciate the importance of Elise's focus on the word that shares equal billing with felony in her title, namely procedure. So to return to the case of Agnes, Robert, and John, as presented by Agnes's, I think of this as her kind of like chat GPT advocate. You know, this is like a kind of like, here's the details of a case, now go. Now, as Cicero, he is not. The conte or story or account he relates is overly precise in the particulars and distinctly unsatisfying as narrative craft. And yet we see in rough but deliberate outline answers to the questions that were known in classical and medieval rhetoric as the circumstances, those queries of who, what, when, where, why, and how that served as the foundation, in Cicero and his commentators, of effective forensic rhetoric. By artfully arranging what Cicero in De Inventione called the attributes of person, place, time, and action and like, the rhetor moves the audience to the confirmatio, or proof of an argument. This is the part of a speech, he writes, that, quote, lends credit, authority, and support to your case. In our example case, we see concerted attention given to the who, Agnes, Robert, and John, the when, such and such hour and year, the where, N precise location in the middle of N township, and the what and how, slew feloniously as a felon using a specific make of sword applied to a precise point of the head. We also, of course, see what Ciceronian rhetoric called the consequence, consecutio, death, in the arms of the woman whose physical proximity to the crime serves as the final physical proof of the act. And this was, written into code, as Elise notes, that it's important that he die in the wife's arms and that she be protecting him. So if we follow the standard history of English law that Sarah has already referenced, the one that holds since Maitland, such Ciceronian touches would have little place in the common law courts. Roman rhetoric belonged to Roman law, canon law, and the inquisitorial and ecclesiastical procedure, where the questions of who, what, when, and where helped judges and confessors elicit the truth from guilty subjects. By contrast, again, this is, a vulgar reduction. The English jury system, the story goes, did not rely on proof, but rather consensus and character testimony to come to their verdict. The implication being, as Sarah notes, that medieval English law cared less about truth in a veridical sense. But in an important set of recent articles, Liz Kamali has pushed back against this standard narrative, arguing that, in fact, the rhetorical circumstances did shape an important, quickly developing aspect of common law, namely pretrial felony procedure, beginning with coroners and sheriff's inquests. And this, of course, is something that Sarah has also written in great detail about, and which serves as the basis for Elise's wonderful first chapter. As Elise discusses in her first chapter, coroners were the first fact gatherers. Again, we've heard this from Sarah, in any death, and hence the first shapers of the narrative that surrounded that death. Indeed, they were tasked with collecting and recording precisely the information we see compressed into our sample appeal, beginning with the who and proceeding carefully through the questions of when, where, how, with what means, with what consequences. Elise arrives, I think, at a similar conclusion as Kamali does, namely that we fail to see procedure, and felony procedure in particular, as a form of argument, balanced precariously between the rhetorical and logical senses of that term, argumentum. A rhetorical argument plays on our desire for narrative satisfaction. A logical argument holds us to the conclusion our evidence presents. We see in our example of Agnes, Robert, and John that the evidence presented relies on the power of vivid detail. That's a rhetorical move. To help these details then become fact-like and thus available to logical reasoning. Agnes, her attorney assures us, followed procedure to the letter. After her husband expired in her arms, she, quote, immediately raised hue and cry upon him, Robert, as a felon, and made suit to 4 neighboring townships, and then made suit to the bailiff of the district, and from the bailiff to the coroner, from the coroner to the next county court, and from one county court to another until he was attached to her suit. So what defense could Robert possibly offer in the face of all this procedural correctness? You may be wondering. The Placida Coronae offers a script for this as well. Tellingly, though, it consists not of an alternative narrative so much as a point-by-point refutation of all the facts Agnes presented in her original appeal. Agnes never had a husband named John, the defense argues, because at the time they weren't married. Nor could Robert have killed said John with the point of his newly sharpened Cologne sword because he had on him that day no weapon whatsoever. For that matter, he couldn't have killed John in Agnes's arms because on that same day and time, she was in a completely different county than she attests. And finally, given that no murder of no husband with no Cologne sword occurred in the stipulated time and place, no hue and cry was raised either. So this strikes me less as a narrative than as a logical exercise dressed in the details of narrative. What the script provides the reader is a set of options for negating circumstantial evidence. Any of these refutations, if corroborated, would deliver a serious blow to Agnes's case. Taken together, however, they become humorously nonsensical. So to wrap up, what this exercise and others in the Placida Coronae highlight is what I take to be the vital core of Elise's thesis, that law lives not just in its theories, but more powerfully in its procedures and processes, in the habits of speech, reasoning, evidence gathering, and judgment that assure legal actors of the law's consistency and futurity. It's no accident, I think, that the term process enters English and French during the period covered by Elise's book with a novel sense, as the path a legal suit should follow. By the mid-15th century, we see the first attested use of the phrase due process. And Elise, I think, has shown us the reasons how this idea, that is, that all of us are owed access to reliable legal procedure, came into being. So I'll end there again with huge thanks to Elise for her remarkable book, for my fellow panelists for the chance to discuss it, and for Marcus for bringing us all together. Thanks.
Thank you, Dean Johnner, and thank you especially for joining us at such a difficult time for Caltech and for your broader community. I appreciate you bringing in, through your commentary, the themes of logicality and rhetoricity, and for bringing us into Chapter 2 and the Placita Corone, which I think, second only to Mirror of Justices, is one of those texts that can be incredibly frustrating to medieval English legal historians and scholars of literature. And so I would suggest when we do convene our support group, we take up those texts in due course. But before then, our third commentator is Alice Ristroff, who is the Les Fagan Professor of Law at Brooklyn Law School and the author of a very powerful law review article entitled Farewell to the Felonry. Professor Ristroff, welcome.
Thank you. I am so grateful for the opportunity to be part of this conversation, and thank you, Elise, for the book. I am a law professor. I'm also trained as a political theorist, and that definitely shapes my work in criminal law. From my perspective as a political theorist and a criminal law scholar, the categories felon and felony are fascinating windows into the way that public institutions, I'll say the state, kind of using that abstraction. Felon and felony are fascinating windows into the ways that the state developed ways to rationalize, and I would say disclaim responsibility for its own violence, the acts of physical force that public institutions facilitate against the members of a society. I think felon and felony are really, really fascinating concepts to see that process. I think, of course, it must be said, the state is itself operated by human individuals. That's why I'm sort of self-conscious about using the term the state as an abstraction. But human individuals do organize themselves into institutions, and to a very significant degree, those institutions then shape the way that individuals think and act, and what individuals know, what they believe. And those ways of knowing that are shaped by institutions, again, encourage us to act in or steer our actions in certain directions. So I say all that as a preliminary introduction to say, for me, I'm kind of thinking about the mass scale use of physical force by some humans against others, and felon and felony as a piece of the criminal law are a really, really powerful lens into that process. I think of modern criminal law as this collection of institutions that organize, rationalize, facilitate official violence towards some subset of the population, that is, those suspected, accused, or convicted of criminal offenses. And so in my own work, I've looked particularly at felony as a legal construct and as an idea about the intrinsic character of the felon, thinking, and this will sound familiar, sound consistent with Elise's book, thinking of felony as something with two faces. Kind of the first face is what the state will do to you, what public institutions will do to someone characterized as a felon. And as Elise mentions, I think that is the only way to come up with some sort of consistent, or that's the only way to kind of identify the categories, the parameters of the category felon, is what will the state do? maybe at times a felony is something subject to loss of property or to capital punishment, or today to imprisonment by more than a year. But those questions about what the state will do to you, I think, is the only sort of solid, tenable way to define the categories of the parameters of the category felon. But felon has always had this other face, this question about who you are, not what the state will do to you, but who you are, your character, your villainy, perhaps. And so because of these two faces, I think, felony works well as a sort of a claim about your character that is also a claim that the state is justified in killing you or taking away your property or imposing imprisonment, etc. So with that, that is the sort of legal or political framework in which I'm reading this book. And we didn't plan this, but I'm not going to talk about chapter 3. So I don't know if Jane was there, but I do want to make some observations about chapters 4 and 5. I do want to make two kind of preliminary confessions or acknowledgements. First, I loved this book, but as someone who is studying human decision-making in law all the time and thinking all the time about what sort of flawed decision makers humans are, it's easy to see that when we think about police officers or prosecutors or jurors. I'm always very sort of self-conscious about my own status as a flawed decision maker, my own being as my own status as a boundedly rational being. So I think this book is terrific, but it's partly confirmation bias. It's partly a feeling of, yes, I was right, seeing Elise look at texts that are so far afield from anything I'm deeply familiar with, and then reaching many of similar conclusions about the category felon. So I think this book is terrific, but again, I have to acknowledge the possibility of confirmation bias. The other kind of confession or acknowledgement that I wanted to make is that although the kind of broad themes and conclusions in the book are very interesting and in some ways familiar to me, I did find much of the book very challenging. And I don't mean that as a criticism of the book. I mean that as a disclosure about myself. I didn't know anything about most of the literary texts examined here, and without any kind of prior familiarity with them, I sometimes struggled in following the argument. Again, I think that's not a flaw of the book. That's just kind of an emphasis on the different position from which I come to it, and maybe I raise that as a sort of preemptive defense if Elise, you or others think, well, you completely misunderstood that, or you got that totally wrong. So with those caveats, again, a couple of questions and comments inspired mainly by chapters 4 and 5. I think in part because the texts were so unfamiliar to me, it might have taken me until chapter 4 and 5 to really feel like I was completely understanding what was happening. At any rate, I found those two chapters fascinating and informative, and I raise a couple of questions, not so much to say these are things you should answer in particular, Elise, but I think sort of questions that are prompted by these chapters, and maybe questions that show why this work and those chapters are so important. So the first question is, how does the category felony relate to the category criminal in this time period? I think Sarah already observed in earlier comments that kind of, many of the questions that we can ask about felony, we can ask about the concept crime or the label criminal. And that, I think, is absolutely true. This kind of what I describe as kind of the two-faced nature, a claim of being a felon as a claim about the person, And at the same time, the only kind of stable parameter to felony is what the state will do to you. I think that's true of crime too. There is no intrinsic way of defining what is criminal. It is a matter of public practices and institutions and what is designated as criminal. And yet, nonetheless, the classification of a person as a criminal does have this kind of social meaning, all these claims about kind of the nature of the person. So I definitely see, a kind of parallel between felon, felony, and crime, criminal, which makes me curious about the category criminal in this period. Today, in criminal law, felonies are clearly a subset of crimes, and the crimes that are not felonies are typically labeled misdemeanors. Although I don't know this history that well, I'm sure some of you with more knowledge can correct me if I'm wrong. I don't think the term misdemeanor arises until maybe the 15th century. And if my search function on the electronic copy of the book was working, I don't think the word misdemeanor is in this book, as it shouldn't be if it's not, it's not relevant to this period. But that does leave me the question, are there crimes or quasi-criminal acts in this period that are not felonies? And that was what was really interesting to me about Chapter 4, where we see this distinction between robbery, a felony, and theft, placed in this category trespass, but not felony. I don't know enough about this category trespass to know whether that is, again, a sort of subcategory of criminal, or what the relation of that is to criminal. But I am curious about that, again, not as a question that Elise necessarily needs to answer, but I'm curious about it broadly, because I think that whatever procedures were used for crimes that were not felonies, a comparison there could help make sense of the particular procedures that were used for felonies. So that's, again, sort of a question for further exploration. The other thing that's really interesting to me, as we think about felony as a possible subcategory of some broader category, criminal law. And this, I think, goes to the discussion of, or the focus on procedure. At the moment the process begins, at the moment the community is undertaking its investigations and decisions, we supposedly don't yet know whether this is a case of felony or whether this person is a felony, right? The process is to find that out. And that really, kind of draws our attention to the fact that it is the accusation that triggers the unique distinctive procedure, not a sort of a prior knowledge about, or a prior certainty about the felon status of this person or this act. That it's the accusation that triggers this distinctive procedural approach, which is still true today. Sort of to be charged with a felony might trigger certain procedures that are distinct than those for someone charged with a misdemeanor offense. But again, the kind of the lingering question for me is, is there more to be learned by thinking about a comparison between the procedures that would apply when someone was accused of theft or trespass or some kind of wrongdoing not in the felony category versus procedures, the felony procedures. So that's one set of just really interesting questions that the book prompted. The second set of questions that I wanted to raise are related to Chapter 5 and the discussion of consent and silence. And here maybe I'm going to talk a little bit more as a political theorist than as a law professor. So part of the felony procedure described was the entry of a plea, and whatever the plea was, there's this procedural demand that a plea must be entered. You can say not guilty, but you have to say something. And I was so interested to learn about this and so excited to learn about Sarah's book, which now I want to read. And this gruesome practice of physical torture by which an accused who didn't enter a plea would be tortured or put to death, compelled to enter a plea or else put to death. So there are lots of great stuff in chapter 5 about what the silence meant, what it, kind of the significance of remaining mute in a world where the consequence of remaining mute was so dramatic. The piece of broader context that I'm curious about, the kind of the bigger question that bigger historical question that occurs to me is why did it matter whether the accused gave consent to a trial? How did we kind of get to a place where hearing guilty or not guilty, hearing that plea was important as a sign of the fact that the defendant had consented to the trial procedure? And that's particularly interesting to me from the perspective of political theory, because those interested in the history of political thought have explored the origin of the idea of the consent of the governed, or the idea that political authority has to be based on consent rather than divine right or some other source of justification. And while I don't know that historical literature super well, I know enough to know that consent of the governed is often traced to this same historical period, maybe late 13th century, maybe developing further into the 14th. You get kind of the formal statements of social contract theory a little bit later in the, say around the 16th century, 16th and 17th centuries, but the earliest references to phrases like consent of the governed come much earlier, again, in kind of this time period. And so that seems really fascinating to me. If we're trying to think about how humans came to see themselves as creatures capable of giving consent and people who had to consent before they could be ruled. And I'm fascinated to know whether, what the timeline is here. If there were a clear established political tradition that political authority should be based on consent, that came before these procedures that Elise is writing about, then we would sort of have a plausible story. But I'm not sure we did. And are there ways in which the legal procedures, the felony procedures that are described here in especially in chapter 5, ways in which they contributed to the development of the kind of political theories about the legitimacy of government being based on consent? I think that's a really fascinating question. And again, I think it just sort of illustrates the tremendous payoff that comes from the kind of investigation that has been done here. I should stop. I didn't actually check when I started talking, so I should stop. I do just want to close because I hope we get to it at some point. I am thinking a ton about the inauguration next week, and that we, sort of what are the implications for the term felon that we are about to embrace our first felon president. I mean, not that we're going to embrace it, but like it or not, we are going to have the felon president. I really curious to know going forward whether this is a moment of transition in the history of felony, where I think, as Elise said in opening remarks, there's been this kind of remarkable consistency in felon and felony over 700 years. Is this particular political turn of events, is it a transition in the way we think about this term or in the power of the term, or is it just a kind of one-off based on the particular character of this individual and the way people react to him? I don't know, but that's something I'm wondering about and just wanted to raise that question as well. Thank you.
Thank you so much, Professor Ristroff, for your comments, and especially for bringing the political theory perspective into the conversation and helping us think about the ways in which felony, defining someone as a felon helps to rationalize state violence. And I think that raises a related question about the origins of felony as an almost entirely capital offense and the much broader use of the term felony today. Although, we know that even if it's an offense that involves fines or incarceration, there's still an element of state violence involved in modern felony. Also, I think opening up the conversation to the felony misdemeanor or felony trespass distinction is helpful, and the encouragement for us to think about the origins of consent to trial and how, or whether it relates to notions of consent in other contexts, including consent of the governed. Lots to think about there. But first, we have our final commentator, Jamie Taylor, who is not obliged to address Chapter 3, just to be clear, although that would be welcome. Jamie Taylor is the Mary E. Garrett Alumni Professor of Literatures in the English department, or Professor of Literatures and English in the English department at Bryn Mawr College. And she is the author of Fictions of Evidence, Witnessing Literature and Community in the Late Middle Ages. Professor Taylor.
Thank you. Thank you all so much. And Alice, I have to say you teed up what I'm going to talk about like in this very, very kind of preternaturally excellent way. And I'm just going to get into it so we have some time to talk at the end. But I want to reiterate what everybody has said. I'll reiterate it probably less professionally than others, which is to say I just really liked this book. I liked it. I liked reading it. And it was one of those experiences where you're taking notes on what the book is actually saying, but then you just take these little paths into your own thoughts because it was incredibly generative. So I'm really grateful to Marcus for bringing me in and to Elise for writing this book. It was incredibly stimulating. What Elise shows us, as we've all kind of registered, is how felony, its definition, its investigative structures, its trial procedures depended on storytelling to create its practice. So in felony, there isn't law and literature, it's law as literature and also literature as law. So for me, Elise's methodological look across law and literature was reminiscent of Saidiya Hartman's critical fabulation, which sifts through archival debris to unearth characters and envision their stories through the tight weft of document, imagination, testimony, and logic. And although Elise doesn't use that phrase, doesn't use critical fabulation, what this book shows us, like Hartman's work, is that medieval felony worked via critical fabulation to produce itself. And it still does, actually. Ideas about and processes around felony haven't changed that much since the 14th century, it turns out. Neither have ideas about justice, which still depend on narrative satisfaction, that sort of feeling of closure. So storytelling is endemic to felony and to justice alike. And what Elise does in her chapters is show how legal agents in the form of pleaders, witnesses, and felons themselves are also literary figures. They're personifications of procedural types. And their literariness means that felonies and felons exceed the moments of their events. So once you are a felon or determined to be a felon, you're a felon forever. So it's not only a description that it kind of attaches like a burr, it prevents other possible personifications. So in the US now, depending on the state, a felon once you become a felon, you cannot then become or be a psychologist, a pawnbroker, a dentist, or a massage therapist. However, turns out in the US, a felon can be president. Felon president, that phrase defies categories that we would assume obviate one another. And it can defy those categories because it turns out we never really had distinct categories in the first place. In the particular case of our new felon president, it seems like the felony stuff hardly matters, since it's unlikely to have any real effect. Judge Merchant sentenced Trump to unconditional discharge in his hush money case, for example, so no jail time, no fines. But still, the name sticks. One Politico article puts it succinctly. It says, and I'm quoting Politico here, "Nothing much will change for the president-elect now that he is a convicted felon. The sting will be in the title itself." Now, Trump, unsurprisingly, won't take the win. Even though he's now immune to prison time or fines, he's still trying to get the title convicted felon overturned. Even though the 2 federal cases against him have been dismissed, he's now fighting to keep the Justice Department from releasing its final report. Trump knows that the story matters more than the conviction itself, and that felony procedure, testimonies, interrogations, the kind of fruitless search for narrative satisfaction will continue so long as he's a felon. Now, one way he's tried to reframe himself as a victim rather than a felon is by calling his legal cases witch hunts. It's a little ironic, given that some of his legal woes have to do with his treatment of women, the hush money payments to Stormy Daniels, and the sexual assault against E. Jean Carroll. And the witch hunt term is extra ironic because the strategy in those cases was less about demonstrating his innocence than creating a story around these women's characters. For example, he began a few years ago calling E. Jean Carroll's claim against him, and here I'm quoting Trump, a fake story, a totally made-up story. But he quickly moved on to calling her not a believable person. And finally, he started calling the whole thing the Carroll hoax. The trajectory of Trump's response to Carroll moves from story to personification to legend, which Elise has traced was an important track felony accusations often took. So what I'd like to try to do today is amplify a thread that runs throughout Elise's book, a thread I think has some bearing in what we're witnessing with Trump now. Throughout the book, even as the subject matter turns to specific storytellers, the body in the case of St. Erkenwald, testifying witnesses, pleaders, or to specific mechanisms of felony procedures like standing mute, Elise's book asks us to think deeply about gender, crime, and judgment, focusing particularly on the ways women's voices are deployed in felony records and in trial imaginaries alike. To take one important example, in chapter 2, Elise argues that the careful depiction of Constance's self-defense in her almost rape obscures her status as a murderer, albeit one without premeditation and with provocation. And this is a change Chaucer makes from Trevitte's version to insist on Constance's moral innocence. Trevette calls her a murderer, Chaucer does not. What we see in this moment is how felony treats women and rape in specific and peculiar ways, both in court and in the court of public opinion. In fact, we see repeatedly in Elise's book that even within the idiosyncrasies of felony process, the treatment of women is particularly idiosyncratic. And now, Middle English actually differentiates between a felon and a feloness. And even though it's an uncommon term, feloness appears in a few legal records, and specifically in the Middle English redaction of Trevitte's Life of Constance, when the jealous knight swears in court that Constance is Hermengild's murderess and feloness. Barbara Hannawald has shown how infrequently female murderers appear in 14th century legal records. There's one female murderer for every 9 male murderers, and the ratio actually still stands in the UK, for what it's worth. In part, it's because courts treated female criminals differently, acquitting women at a higher rate than men. Because several records show women were thought to be incapable of physically wielding weapons and or emotionally incapable of summoning the kind of rage and hate required to kill another human being. But there are different approaches to female criminality, of course, also. So in the 15th century, the Malleus Maleficarum, which I've chosen because it's the first and most thorough witch hunt manual, said that felonesses were naturally better at deceit. So they were less likely to be found, or if found, less likely to be found guilty after they offer convincing false testimony. So the complicated picture around women and fallacy, and I'm barely scratching the surface, it coalesces around anxieties about the ways women might be particularly deceptive on one hand, and the ways they must be protected on the other. And I'd like to think through this contradictory balance by examining the legal and literary life of one of Middle English's most complicated women, Crusade. Chaucer's Troilus and Crusade leaves Crusade, the Trojan princess, in the hands of the Greek army, having been handed over by her father in exchange for one of his soldiers. Crusade's Trojan lover, Troilus, is beset with grief. Crusade is sad, but more resigned. So this is all book 4 of Troilus and Crusade. As Crusade tells Troilus, there's no point in protesting because, and this is what she says, my going is granted by Parliament, thus the decision can't be contradicted, and certainly not by my judgment. All she can do is promise Troilus that she will return in 10 days, but inevitably, in 10 days, she can't leave the Greek camp. She apparently falls for the leader of the Greek army, Diomed, and Troilus, who's despondent, dies in battle. Now, in the first moment of the synopsis, when Crusade is first given to the Greek army, we witness Crusade's recognition that women don't really get the opportunity to protest. Their fates are determined by a government and a set of laws that are not set up to hear their complaints. In the second moment, when Crusade does not leave the Greek camp as she promised, that one invites readerly judgment, and the story's narrative satisfaction comes at her expense. Early modern readers on up to contemporary critics have read Crusade's apparent about-face from Troilus to Diomed as Chaucer's depiction of women's fickleness. But Elise's work prompted me to check to see how Crusade voiced her love for Diomed and her rejection of Troilus, and it turns out she didn't. The narrator reports that the story tells us that she gave Diomed Troilus's horse as an expression of her love. And the narrator then says that he finds in stories elsewhere that Crusade really fell for Diomed when he got hurt in battle. And here's how the poem puts it. Men say, not me, that she gave him her heart. Men say, not me, the narrator says. The truth in Crusade's fickleness is made visible and judgeable by its common knowledge. The narrator goes on to explain, but truly, the story tells us there was never a woman who made more woe than she when she falsed Troilus. So we get this layering of hearsay and reputation, of story and gossip that add up to the final conviction that Crusade is the cause of the most sorrow among all men of all time. And the narrator punctuates that conviction with the word truly. This sexist satisfaction, summing up a very complex story of love, political trafficking, and survival by shrugging shoulders with a kind of women, am I right? Renders a social truth already foregone as a legalistic conviction. Via that condemnation, Crusade becomes a circulating exemplar. Her name, alas, is published so wide that for her guilt, it ought enough to suffice. Like E. Jean Carroll's name in the Carroll hoax, the name Crusade becomes a shorthand for male condemnation of female deceit, and by extension, for the exoneration of men's behavior. So now, just as Trump keeps E. Jean Carroll's name alive so that he can persistently denigrate her, so too do later writers with Crusade. In the 15th century, Robert Henryson sets the testament of Crusade many years after the events of Troilus and Crusade. And Henryson explicitly says that his purpose is to exonerate her as best he can. I shall excuse, as far as I may, your womanhood, your wisdom, and fairness. Now, in the Testament, we encounter Crusade after she's been dumped by Diomed and left destitute. So she isolates herself in her father's house. She's upset, and she complains about Venus and Cupid having left her to an awful fate. Henryson imagines his poem as an opportunity to give Crusade her voice back, by re-adjudicating her in a new court of law, this time with gods serving as pleaders, witnesses, and judges. Cupid accuses Crusade of blasphemy and defamation, and Saturn and Cynthia sentence Crusade lawfully, that's Henderson's term, to leprosy and poverty, complete with a formal bill of judgment. Now, leprosy works on Crusade's body as St. Erkenwald's body does, as incontrovertible evidence that speaks for itself. Still, Crusade doesn't really get a say. She doesn't testify in this cosmological trial at all, and her only testimony comes later when she writes her last will and testament and implores all the ladies of Troy and Grace to heed the warning of her life choices. The end of the testament returns to the narrator, where he offers a complicated claim about what standing mute means, including what it looks like when men insist that women speak on behalf of an already assumed conclusion. So he says, like, now worthy women, pay attention to what happened to Crusade, like, you know what's going to happen. And then he abruptly ends the text. I want to spend a little bit of time on this line. He says, since she's dead, I speak of her no more. Only Crusade's death allows her to stand mute in her own condemnation. That said, the story of her felonious suffering has already taken hold. And in fact, death doesn't let Crusade stand mute for long. We continue to get male authors voicing her treachery in the service of felonious exemplarity. In the late 16th century, someone, and it's very contested who, wrote the last epistle of Crusade to Troilus, imagining that the leprous Crusade writes one last letter to Troilus to express her sorrow for a life misspent with Diomed. Now, there's no narratorial framing here, so it's presented as Crusade's own words. And this Crusade is angry with Troilus for standing mute himself and allowing her to be taken to the Greek camp. How could your knightly heart consent, or eyes abide the sight, to see me under Diomed's guard from Troy to the Greeks so stray? This is what she says in her letter. The term consent pointedly emphasizes that she herself was not granted it, despite the fact that she has been made to take the blame for the aftermath of her political trafficking. As though she recognizes the impossibility of giving her own testimony once she's already been judged. At the end of the epistle, Crusade relinquishes her story to Troilus. She says, on my tomb, some epitaph engrave as you like it best. So farewell, this leper's knight can show of me the rest. The repeated demand that we get Crusade's side of the story for 2 centuries after Chaucer's Troilus and Crusade demonstrates an ongoing discomfort with a woman standing mute, using silence in her own defense. Elise points out that women standing mute made men deeply uncomfortable, and that judges would do just about anything to demand women's speech, specifically so that there was some fodder for analysis and judgment, whether legal or narrative or both. In Crusade's literary legacy, female muteness is reframed as male ventriloquy, such that Crusade does not deploy legal silence, but rather is silenced by the court of male storytellers. Now, E. Jean Carroll has pushed back against such male ventriloquy. Trump was told to stop his storytelling, and he didn't. So she sued for defamation and won. He's still appealing both the sexual assault and the defamation verdicts. And his argument is that 2 other female witnesses unfairly offered testimony about their own sexual assaults. Now, if this appeal doesn't go through, the next step is the Supreme Court, and we'll have to see who gets the last word there. Thank you.
Thank you so much, Professor Taylor, for bringing a fresh perspective, including applying Hartman's notion of critical fabulation to our topic today, and bringing in this concept of witchcraft, still very much a living concept today, and the feloness distinction, which we might put up there with the outlawry wavery, distinction as another example of ways in which women and men were treated distinctly. So at this point, I would like to give Elise a few minutes to respond. I realize we are running short on time. And so, Elise, if you want to respond to some of the points that have been made, and then we'll see if we have some time to open things up for Sarah, Jennifer, Alice, and Jamie to jump in if they have other questions that they really want to hear from you, a live response before we sign off. Go right ahead, Elise.
Okay, so I'm gonna try to be really brief. Thank you all so much. I have many pages of notes going on here, so I will not get to everything. One thing that sort of seemed to go throughout, or at least through several of the comments, is why is felony a problem? Why is it different from other things? Why is it a lot of things that are true of felony are true of crime more generally, as Alice said, and then a lot of things that are true of felony are true of law more generally in the medieval period, as Sarah said. And that is absolutely true. Although some property stuff is pretty clearly defined in medieval law. They cared enough about that they were going to define it. And I think that's the thing for me, is that, you know, it is the thing for which you don't get to come back. And so it is the way that we define the bounds of society, right? If you are a felon, you don't get to come back, except for Trump. I'll get to that in a sec. But if you are a felon, you don't get to come back. And so it seems like, and I'm grateful for Alice for bringing in the political theory part of it, it seems like a place where we, you know, avoid definition at our own peril, because we, it is, if we are using it to define the bounds of our society, then we run the risk of something like Trump, where, you know, Trump is shielded from all of the consequences, basically, of being a felon. He is, for all practical purposes, not a felon, in name only. And that is sort of because we have persisted in not defining it. You can't actually bring the full force of a term like that you want to have down on someone if you don't define it. But we have also decided not to define it, or avoided defining it, because its flexibility has allowed us to exclude who we want to exclude. Especially, I think, in the history of American law, it's a continuation of segregation. And so if you define it, then it might apply to everybody. But if you don't want to define it, then you can use it however you want. And that is coming back to bite us, is basically, I think, what has happened. And I think that's one reason why felony feels special to me. And then another reason is the sort of literary side of it. It's generative from a literary sense. This, you know, I'm really grateful for the critical fabulation term, because it works through critical fabulation, and it is creating and recognizing its object, as Jen said. It's something that is very literary. It functions in a very familiarly, like, as a person trained as a literary scholar, this is very familiarly literary and less familiar to the legal arena. And it's also, you know, from the political theory perspective, you know, a way to disclaim responsibility for its own violence, as Alice was saying. Like, it's a way to project responsibility for the violence that we inflict on felons onto the felons themselves, right? Felony is not something that we punish. Felony brings punishment down upon itself. It's sort of auto punishing, auto punitive. And just a few more things. I would like to join that support group. Many tears have been shed over common law, so that would be helpful. So, the sort of gender aspect of it, it was something that I got to the end, and I was sorry that I did not make more explicit throughout the book, but I think it is there, and it came sort of the very first time I presented anything on this book. A graduate student got up and was like, "Thank you for such, like, an explicitly feminist work." And I was like, "Is it? I guess it is. Yeah, I guess that is." Yeah, I mean, yes. But it's definitely a primary thread through the whole book. I don't say that it is, but it obviously is, and I'm really grateful to Jamie for bringing that out. And I wanted to respond actually, Sarah, to your comment about the fourth chapter and the characterization of it as a failed system. And someone has brought this up before, so I think that I am probably using the wrong term there from a legal perspective, because what I recognize, so this is a chapter on the fact that conviction rates were very low, despite a lot of sort of fiery rhetoric about how terrible felons were, and robbers in particular. So why did conviction rates remain so low? And I recognized in it a literary pattern of failure that I associated with something like the Good Thief story in Piers Plowman, where he brings it up and it kind of peters out and he doesn't resolve it. And then he brings it up again and then doesn't resolve it, and brings it up again and doesn't resolve it. And at the very end, his last word on it is, "What befell of this felon I cannot fairly show." So can't tell you what happened. And so it's not a failure, really. So I think my terminology there is wrong. It's not a failure, but in a literary sense, it's playing with the idea of failure. Like, what if I keep on bringing up this story and I just don't resolve it? And what is that doing for the narrative? What is that doing for the overall story if I keep on bringing this up without resolving it? And I felt like I saw that gesture in these repeated indictments. And another way to think about indictment as its own form of punishment, right? Indictment is a punishment. You then have your name written down next to the word robber. That's pretty bad. But that function seems to me closer to this kind of like repetitive, obsessive literary failure than to sort of, I don't think I didn't mean to say that the legal system itself was failing. I think we would all like lower conviction rates. So in some ways that was a great success. But that sort of literary move of failure is kind of what I was talking about. And I think I will actually just leave it there. There are so many more things to say. But I would love to have you guys talk to each other and have more voices in this.
Wonderful. Thank you so much, Elise. And I will resist the Socratic professor's temptation to cold call, and will hope that any of you who'd like to hear one of your questions answered directly might just open the conversation. We have just about 10 minutes, or maybe even a little less than that, remaining.
Elise, I want to return to your statement that felony is the same that you don't get to come back from. Yeah, you do. They all do. And I think it is important to remember that in this period, with the high acquittal rate, just because people acquitted you didn't mean that they didn't think you were a felon. And I think that is, I mean, again, it's what the legal system is thinking of you, and judges and so forth, versus the people in your community. They all know you did it, but they don't think that you're a bad enough person you need to be executed. And particularly if it's something like homicide, you probably sat in prison for a few years already, just waiting for your trial. And I know that prison then isn't a sentence, but everybody's sitting back thinking, oh, the guy's life is completely ruined. So, I mean, this is it. I think that it is something you do come back from. And actually, that's part of what makes it so exciting, to think about sort of that perspective of what must it be like to come back from being a felon, and, reconciling with your community and finding your place in it, even though people do think terrible things about you.
Are you a felon if you're not convicted?
Well, it's all in the eye of the beholder, right?
Actually, I'll just jump in on that a little bit. Yeah, I do think it's in the eye of the beholder, but there is this kind of terminological question that many in criminal law are struggling with now, with terms like ex-felon. What kind of language do we use to describe persons who have felony convictions, but say have served their sentence and come back? I think that there is always this sort of question about the social meaning or the, sort of lay use of a word versus the legal categories. And there absolutely is a sense in which Trump is a felon, and he will be, even if his convictions are overturned, in the eyes of many. And there is a sense in which Trump is not and never could be a felon in the eyes of many of his supporters. But I guess I just also want to kind of throw out, the way that I kind of hear the claim, felony is that which you don't come back from. It's not. I guess I would think of you, Elise, as saying, not in the sense that you never come back from prison in the modern world, but that your political status is changed in this fundamental way, at least to those in whose eyes you are a felon. Like that's the sort of permanent change that I heard, and I think there's a lot of truth in that, and then that explains a lot of the kind of modern collateral consequences that Elise was talking about. So they kind of come back in the sense that they are released from prison and come back to the community, but they're sort of a permanent change in political standing that is I think one of the modern consequences of felony.
And I would add that I think this is ultimately becomes a really nuanced question, like who gets stuck in the whirlpool of felony and who is allowed to bounce back, whether by sort of like community support or whatever. And what are the mechanisms, to go back to Alice, your claim, like what are the mechanisms of the state to allow some people to bounce back and to keep some people kind of stuck in the whirlpool of felony? I think that's a really important question. And I actually think when I was writing up the stuff on Crusade, and that was one of the like tracks that I was like, oh, this is a totally new way for me to understand this trajectory of Crusade. For me, that was a really complicated example of where you can't quite disentangle sort of community judgment from legal condemnation, from moral condemnation, and the stickiness of it, right, in the long trajectory of her literary life, I think sort of keeps us talking about what is success, what is failure, how do we keep returning?
I think that Elise was, again, one of the most important sort of paradigm shifts that your book helped me make, was to, in some ways decouple felon as a, again, I'm sort of like overly invested right now in grammar and, nominal categories, but as a noun, as a descriptor, as an attachment to person, from the ways that, the state, a social community in ad hoc and formal ways, then measure consequences upon that person. So I think, again, it doesn't surprise me that felon would be an open category, but property would be clearly defined, because in fact, that's how you measure felony offense, is by a clearly defined structure of consequences that follow from however you want to convict that. So if a community decides, yeah, you're a felon, but you know what, we kind of love you anyway, and like come back in and you still got your house and your life, versus you're a felon and, it's a capital offense and, here you go, I think is really, actually, it's very complicated. As everyone said, it's very, relational, and I think also impinges on this question of, the kind of eye of the beholder with a felony president. If there are no functional consequences for being a felon president, then it does remain a category, like Crusade's category, that can be debatable, that is, attached to your personal feelings toward the person. We measure felony in concrete, property-based, and, physical life-based terms.
Elise, maybe we'll give you a moment if you want to respond to anything here. I'm so sad to cut off the
Yeah.
conversation.
No,
Why don't you go ahead?
just very quickly, I know, Jen, you're thinking a lot about accounting, and I'm really grateful for bringing that in, because that is a sort of, to bring it back to the issue of felony versus trespass or felony versus misdemeanor, this comparison, that is a way in which they are different, right? Is that for trespass, say if we're comparing theft and robbery, for trespass, it matters how much you stole. If for robbery, which is a felony, it does not matter. It does not matter how much you stole. There's a way in which we stop accounting once we're in the felony territory. It's a sort of binary situation. And there's something that I started thinking about afterwards. I'm writing like a sort of follow-up article, basically, is about the association between felony and villainy, and the sort of Arthurian arch-villains. Because, and I think this is the thing about the low conviction rates, is the question is not, did you murder him? Like, yeah, sure, maybe you did. The question is, are you a felon? And if you're saying that felons are, Mordred, felons are these arch villains, the evil stepmother who doesn't get a happy ending, then, maybe Robert the murderer is not really a felon. Like, he doesn't quite fit into that. And so he's not actually a felon. And that's why he gets to come back, even though he is a murderer. And so there's this binary kind of sense to felony that resists accounting. And I guess we probably should leave it there.
Great. Thank you, Elise. I just wanted to briefly remind our audience before we sign off that they might keep an eye out this fall on the MCLR Plus website for the written version of this book forum. And also on that website under resources, if you look under the word felonies, you'll find a bunch of related readings, including some by today's commentators. Finally, I want to say a hearty thank you to our author, Elise Wang, for her thought-provoking book, and to our wonderful commentators, Sarah Butler, Jennifer Johnner, Alice Ristroff, and Jamie Taylor. Thank you also to Marcus Duba, who the wizard behind the Zoom or YouTube curtain, who organized today's book forum. And of course, thank you to our audience. Hope to see you all at the next book forum.